amendments to Part B of the pattern of examination under the scheme of the examination for control for Group 1 services prescribed in the government order first read upon. In light of certain court cases filed in this regard and the observations of the Supreme Court of India in the case of Baloji. The first question that I am saying is, the first issue would be, Baloji Badawat is no longer good law if the law was with regards to the classification at the time of the preliminaries.
Which judgment is not a good law?
Baloji Badawat.
Is it overruled?
Yes, not overruled in terms of specifically saying so, but the ratio laid down in Baloji is no longer the good law, because the Supreme Court in the judgment that went up from Madhya Pradesh faulted this mechanism that was upheld in Baloji. So the state can't be heard to say that a 2-judge bench judgment of the apex court will hold the field and not the 3-judge bench judgment, which is the subsequent judgment of the apex court.
Yes.
So the premise on which
this Baloji principle is watered down, we can say, in
yes.
which matter? In which matter?
Independent. Independent.
It is arising out of Madhya Pradesh High Court.
Yes. So and that is by a bench of 3 judges. Both on the theory of subsequent judgment prevailing over an earlier judgment and on the quorum strength theory. They could not have relied on Baloji Badawat. Or even assuming that they do, it was incumbent on their part to say there are 2 kinds of judgments. Our empirical data goes by Baloji, that is why we are doing Baloji. Otherwise, the very issuance of such a GO, the decision-making process stands vitiated.
Yes.
My contention, therefore, is that the fulcrum of GOMS 29 is based on a judgment which is watered down, to borrow the expression, largely by a contra view taken by a larger bench subsequently. I will not trouble your lordship with that judgment, my lord, because your lordship, it has been repeatedly brought to your lordship's notice.
What is the exact name of Madhya Pradesh judgment? The first name, it's a batch of petitions.
The subsequent
held by Supreme Court.
The subsequent. It is there in my book at page 458 of the paper book. 478 in his book, in the same book. 478 of his book.
Same writ petition.
The same writ petition, sir.
478.
In your writ petition?
No, in
Deependra Yadav.
Yes.
Yes.
That is Deependra
Yes.
Yadav.
2024 6 SCR 36. But what is placed before your lordship is went into exactly the similar question, and your lordship may see that this is the
Baloji judgment is on record. Baloji is on record.
Baloji is not on record. I can pass on the judgment. Where? Ballots. Quota. Yesterday. Maharaj, I'll take your lordships to Baloji. Your Lordship may kindly come to para 21 of that judgment. Problem with the impugn GO is it partly adopts Baloji, partly winks at various other observations made in Baloji. Kindly come to para 21 of that judgment, which I've just passed on.
Yes.
The Appellant Commission, which has been constituted in terms of Article 315 of the Constitution, is bound to conduct examinations for appointment to the services of the state in terms of the rules framed by the state. It is, however, free to evolve procedure for conduct of examination. While conducting the examination in a fair and transparent manner, as also following principles of fair play, it cannot completely shut its eyes to the constitutional requirements of Article 355 of the Constitution, which reads as under. Now, how you deal with Article 355, how you deal with reservations thereof, Indrasani admittedly is the last word as of today. And both of them have showed your Lordship that the manner of silting the reservation by the manner in which it is being done would run contra to the ratio of Indrasani. Kindly then come to paragraph 22.
Yes.
How the Commission would judge the merit of a candidate is its function. Unless the procedure adopted by it is held to be arbitrary, against known principles of fair play, superior courts would not interfere with it. Therefore, we labor to show your Lordships that the touchstone is it arbitrary? Is it contrary to the known principle? That the alternative is arbitrary is a statement borne out by them in an affidavit. I'll show your Lordship what they say in the affidavit at length. Interestingly, I'll show your Lordships the nuances of that after I finish this paragraph. The state framed rules in light of the decision of the High Court in Jaffer side. Per se, it did not commit any illegality. The correctness of the said decision here and before is not in question having attained finality. The matter, however, would be different if the said rules per se are found to be violative of Article 16 of the Constitution. So even here the division bench says, if you examine it from the point of view Article 16 and find it bad in law merely because it was a rule made in accordance with that law, it will not stand to reason. Notwithstanding the basis, that is Jaffer Javed, the bench says, however, would be different if the said rules per se are found to be violative of Article 16 of the Constitution of India. Nobody has any fundamental right to be appointed in terms of Article 16. It's nobody's case, it's tripe law. It merely provides a right to be considered. A procedure evolved for laying down the mode and manner for consideration of such right can be interfered with only when it is arbitrary, discriminatory, or wholly unfair. We are putting it both on the ground that it is arbitrary in as much as it violates the dicta laid down by the apex court in multiple cases, and on the ground that while you come to this of the many alternatives, you do not examine the other alternatives. You only say this one judgment. That itself, the Lordships often say, what is arbitrariness? When you consider only one set of facts. You do not consider all relevant factors. Let us for a minute assume that that judgment that they are relying upon, namely Baloji Badawat, was binding. They would also have to see the other judgments after Baloji Badawat, because they said that Baloji Badawat is not good law.
In a specific, it is not overruled.
No,
and
it's
it
not
is not
specific.
even considered in Deependra Yadav.
No, unfortunately not.
It is not considered.
Not.
Yes.
My lords, Then in para 23, the very same bench deals with Chattar Singh versus State of Rajasthan. Well, it's the reason why I'm showing your Lordship's Chattar Singh is, Chattar Singh laid down the formula that while you are conducting tired assessment, the purpose is to filter. If your end product is as heavy as your filtration product, then the very purpose of filtration does not affect. That is what they say. I'm going to show your Lordships. When they say they are doing 1:50, they don't stop at 1:50. The number of people who come in at the end are much more than the 1:50, marking the 1:50 ratio.
Continue after the break. We'll continue after the break.
Yes.
My lord's kind leave, my lord Lordship had directed us to hand over the
Numbers.
list of 200 cases of limitation power. Obliged, my lord.
Item numbers 85 to 91, my lord, they are connected to other matters. I'm giving a list, they may be posted along with these.
Get these matters listed in the on Monday. Yes, madam.
85 to 91 are connected to other matters, my lord. I've given the numbers, they may be posted together, my lord.
85 to 91 final hearing.
Final hearing. Those are insurance appeals, our appeals are also to be posted along with
85
them.
to 91 as spread list with MSCMS such and such.
Much obliged.
You mention after the break.